I have you logged in. Give me just a second.
Okay.
Good morning, Ms. Serby. Are you here for Credit Acceptance Corporation?
Good morning, Judge. Yes, I am.
All right, this is 2401313 Credit Acceptance Corporation versus Courtney.
Good morning, Judge Francesca.
And there it is. Judge Victoria Shackleford reinstates the garnishment. 6 months of no payments means the plaintiff's patience just ran out. This ruling feels fair, but it also shows how simple miscommunication between HR and creditors can spiral into legal chaos. What do you think? Should the judge have given her another chance, or was this the right call?
Secretary for Plaintiff P87205.
Ma'am, can you tell me your name?
Courtney Kelly.
All right, and I have a note from Ms. Kelly. So it looks like there is a motion for installment payments, and I have a motion to set aside the payment plan, and that's filed by the plaintiff in this case, saying that the defendant failed to abide by the terms regarding installment payments. And then Ms. Kelly responded to that and said, I, Courtney Kelly, would like to request a hearing in the matter of this case. I received information that my payments were done and the agreed amount had been paid. I stopped payments from coming out of my check at work. I was no longer repaid, so I thought, in order to pay, so I thought. So Ms. Serby, what do you have still due and owing on this?
At this point, there's still the current balance of $12,532.93. There has not been any payment made since the installment payment order entered into in July. And any payment that was received from defendant's employer after the date of that installment payment order was returned back to the employer. So I'm not sure what correspondence that defendant's referring to, but there's certainly still a balance due and owing on this file. And there were no payments made on the previous installment payment order entered into back in July.
Wow. Okay.
Ms. Kelly?
Okay, so basically my last job, which was Casey Jones, I no longer work there for many reasons. I'm actually in a process of suing the company. The HR informed me that that they received information from you guys stating that my payments were done being made and I no longer needed to pay out of my checks. I then spoke with someone on the phone through you guys, Credit Acceptance, because I was confused. I then spoke to some lady. I'm gonna say she was a foreigner lady, and
now here's where things get messy. Miss Kelly claims she got an email saying her payments were done, but in court, saying someone told me doesn't cut it without proof. If she really had that email, it could have changed everything. Always remember, documentation wins cases, not confusion.
Something to my email basically stating that once it was like $2,000 or $3,000 met, that it would be dismissed. It was all confusing. She sent something to my email and I would have to go back through my Gmail and see what it says, but I literally thought that I was done making payments. I would have just continued to make payments after I left that job if I had known. I had no idea.
Ms. Serby, so there was a garnishment on wages some time ago. Is that correct?
Was. Yes.
And when did that garnishment end?
That was suspended on July 11th of 2024. So as soon as the installment payment order of $250 per month kicked in, that garnishment was suspended. So it wasn't released, but I mean, we stopped collecting on the garnishment back in July. So I think there was a couple of payments.
And you received 0 cents then. And how much was it?
Sorry, since the last installment payment order, we received a couple of payments. It looks like $160 in July, $149 in August, and then $57 again in August. But we had sent all of those back to the employer because the installment order was in place. And the employer would have also been ordered by the court to cease the withholdings while that installment order was in place. And so I also believe that the letter that defendant was referring to, or the settlement that defendant was referring to, was a settlement offer that expired because it was not paid in time. So there was no
Okay.
payment on that either. So
What was the
there's still a
settlement
balance. The settlement was actually offered on June 4th of 2024. And so that was to be $2,571.36, paid by September 4th, 2024, or the offer will expire. And it states that right on the letter. So that was actually offered before the installment payment order kicked in. In any event, there's been no payment on either.
I mean, Miss Kelly.
Yeah, I'm flabbergasted right now. Like I said, she just said that there were continued payments made from me, and I'm telling you, Your Honor, I
No.
didn't.
No, that's not what she said. She received further garnishments. So basically, I granted a motion for installment payments, right?
Okay.
So you pay, and then
All right,
she
folks. Right off the bat, we've got Credit Acceptance Corporation versus Miss Kelly. This sounds like a standard debt collection case, but watch closely because confusion over installment payments and garnishment orders is about to cause a legal tangle. Do you think she's genuinely confused or trying to dodge responsibility? Let's
received 169, 149, and 57, right? From
Yes.
not from you, from the employer.
Right, and what I'm
Correct?
telling
Oh,
you,
wait. Is that correct? Wait, Miss Serby, that's correct.
Yes, that's correct.
And you had to send it back because I had issued the installment order, which quashed the garnishment. Yes.
Yes.
Okay. So, Miss Kelly, you owe the money.
yes,
And they tried to give you an installment payment plan and you haven't made any payments on it. And I mean, I can't.
I know, confusing. I literally being employed at that job November 19th of last year because of fiscal grievances and how they operate, Your Honor. I literally would have made the payments. I came all the way to the courthouse to ask you for the payment. This was literally a miscommunication on my HR and myself.
All right, well, here's what I'm doing. I'm granting their motion to set aside the order for installment payments. And the writ of garnishment will issue. And I'm hopeful that the two of you can, maybe have some discussions. You can contact them and try and work something back out due to the misunderstanding, but they've not received any money for, 6 months now. And it's a judgment that's due and owing. So that is my ruling.
Thank you, Judge.
Okay, but you two can reach out to each other and try and make some other arrangements if they're interested.
Okay, yes. Is there any way I could get your information to reach back out to you?
Yeah, we can, Judge, you want to put us in a breakout room, I can chat with her.
Yeah, we'll put you two in a breakout room so you can exchange information, okay?
Thank you.
All right.